Today, we will be discussing the erosion of at-will employment in New York State. Let's get started. First off, what is at-will employment? At-will employment is employment where either the employer or employee can terminate the relationship at any time for any reason. It's either written or oral, and it is implied due to certain circumstances that show mutual intent. In New York State, most employees are at-will employees. Here are some terms to know. The first term is whistleblowing. It is defined as an employee's disclosure to government authorities, upper-level managers, or the media that the employer is engaged in unsafe or illegal activities. For lack of better words, you are basically telling on the company for doing unethical things. The second term you should know is wrongful discharge. A wrongful discharge is the termination of an employee in violation of the law or an employment contract. It is also known as wrongful termination. In New York State, wrongful discharge is very rare due to most employees being at will. There are 5 main exceptions to the at-will employment doctrine. Under common law, the exceptions are public policy, implied contract, and covenant of good faith. There are 2 statutory exceptions, illegal discrimination and retaliation. The first exception is public policy, and this is where an employee is wrongfully discharged when the termination is against an explicit, well-established public policy of the state. In most states, the employer cannot terminate an employee for filing a workers' compensation claim after being injured on the job or for refusing to break the law at the request of the employer. Under the majority view, public policy may be found in either a state constitution, statute, or in administrative rule. The public policy exception is the most widely accepted and is recognized within 43 of the 50 states. Next, the second major exception is the implied contract exception and is recognized in 38 of the 50 states. Within implied contracts, no express written instrument regarding the employment relationship exists. Employment is typically not governed by a contract, so an employer may make oral or written representations to employees regarding job security or procedures that will be followed when adverse employment actions are taken. If so, these representations may create a contract for employment. This exception is prevalent within Rooney v. Tyson, when we see that Kevin Rooney entered into an implied contract with the agent of Michael Tyson. When Rooney's employment was questioned, he was supported by the implied contract exception. The last exception under common law is the covenant of good faith, and it is only recognized by 11 states. The exception for covenant of good faith and fair dealing represents the most significant departure from the traditional employment at-will doctrine. The first way to interpret covenant of good faith is for employer personnel decisions to be subject to a just cause standard. The other way this is interpreted is that termination is made in bad faith or motivated by malice. New York State Division of Human Rights prohibits discrimination based on these protected classes: race, creed, national origin, age, disability, gender, sexual orientation, and marital status. To start off with the statutory exceptions, we have illegal discrimination. The New York State human rights law is among one of the broadest anti-discrimination statutes in the country, for the law prohibits discrimination in hiring and firing of an employee, discrimination in compensation, and discrimination in the terms, conditions, or privileges of employment. It also prohibits discrimination in employment based upon military status, sex, disability, pregnancy-related condition, domestic violence victim status, genetic predisposition or carrier status, or familial status of any individual. Employees who file complaints of discrimination are protected from retaliation by their employers. The law applies to all employers with 4 or more employees. It is also noted that sexual harassment is unlawful even if the employer has fewer than 4 employees. A recent case that took place is Richardson versus the City of New York. Within it, 6 African Americans filed a complaint against the City of New York that the FDNY's hiring, job placement, and compensation discriminated against African Americans. They are disproportionately hired and are therefore poorly represented. As a result, the City of New York was in violation of the human rights law. The last exception to the at-will doctrine is retaliation. Within retaliation, there are federal and/or state laws that prohibit employers from firing employees in retaliation for engaging in legally proper, necessary, or desirable activities. The protected activities include claiming minimum wage or overtime compensation, engaging in union activities, opposing unlawful discriminatory practices, filing for workers' compensation, and whistleblowing. Erosion of the employment at-will doctrine. Erosion can be defined as either the fact of a good quality or situation being gradually lost or destroyed, or the gradual reduction or destruction of something. You're an employee. Your employer puts a handbook in front of you, so everything included within it is implied. There are no assumptions or speculations. We now see the employment at-will doctrine eroding within the state of New York due to the diminishing enforcement of implied contracts. In other words, employees cannot be fired for no reason at all. The end.